All right, guys, this is going to be my video where I talk about all of the judiciary. So we'll get into civil rights, civil liberties, the rest of the days this week. If I don't finish by this weekend, I will be posting videos over the weekend because you've got this test on Monday. All right, so let's talk about the judiciary. Amicus curiae brief. If interest groups or individuals want to influence the Supreme Court's decisions, they can write an amicus curiae brief, basically this persuasive document. They'll mention things in the Constitution. They may mention past cases and precedent, but it's just simply a way that we as individuals and we as interest groups can try and influence the Supreme Court. The Supreme Court will get a lot of amicus curiae briefs when the case is one of these landmark decisions. So like Obergefell versus Hodges, which was the same-sex marriage case, they received a lot of amicus curiae briefs. Appellate jurisdiction is just the power a court has to hear a case on appeals. We have a three-tiered federal court system. You have the Supreme Court at the top, then you have the appellate courts, and then you have the district courts. So the appellate courts, that second tier, they hear cases on appeals, and then the Supreme Court hears like 97% of their cases on appeals. The Attorney General is the head of the Department of Justice in the United States. You could just think of them as the number one attorney for the federal government. If a state is not complying with federal law, that would be the Attorney General that would go after the state in that instance. Okay. Binding precedent. A good example of this would be when the Supreme Court makes a decision, it is now binding precedent on the lower courts. Those lower courts now cannot rule differently than the Supreme Court did in a similar case. Okay, so the lower courts are bound by the higher court's decisions. Petition for certiorari. Okay, so if you feel like, let's say you land in a district court and you feel like that lower court got the case wrong, you feel like there's something wrong with federal law maybe, that it's at odds with the Constitution, you can write a petition for certiorari for a higher court to hear the case. They may hear your case, they may not, but as you start that appeals process, you're going to write a petition for certiorari. Okay, so take one of the cases we know like USA versus Lopez. At some point, Lopez's attorneys wrote a petition for certiorari saying, hey, this federal law is not, it's not just, it's unconstitutional. Supreme Court decided to hear that case. And then when they did, they went on to rule that law unconstitutional. Okay, there's three different opinions. There's the majority opinion. So I'm jumping down here. Majority opinion is the law of the land. So when the Supreme Court makes their decision, and those five justices agree one way or the other, one of them or a couple of them could write one of them would write the majority opinion. That is now law of the land. So they're basically saying, here's the new law of the land. Here's why the majority of us agree the way we do. Concurring opinion, you may agree with the majority opinion, but just for different reasons. So you're going to write this concurring opinion. The dissenting opinion is why you as a justice who voted against the majority, why you feel like the court got it wrong. Okay, really important concepts: judicial activism, judicial restraint. Judicial activism. Activists feel like the courts should correct social injustices where the other branches have failed to do so. Whenever the justices, or whenever the court, it has made a decision and it's now going to change policy in the United States, that's really considered activist. All right, so the Obergefell versus Hodges decision is considered an activist decision. It was not something that was, made. That was not a decision. That policy was not changed nationwide based on voters informing their legislatures or the lawmakers changing policy. Was policy changed by the Supreme Court. Whenever the Supreme Court has changed public policy, they're acting in an activist way. Just think actively changing public policy. Judicial self-restraint basically is the idea that the courts should defer to the other branches. The courts should not be changing public policy. They should not be striking down a lot of laws. They should only be striking down laws and changing public policy in the most egregious cases, in the most obvious cases where law is at odds with the Constitution. Okay. The Activists tend to be your more judges that would follow a philosophy of not original intent, but rather we should look at the Constitution in light of the changes that have happened in society. Whereas those justices that are more of self-restraint say we should use the framers' original intent when deciding cases, that idea of strict constructionism. Okay, the Litmus Test. The Senate Judiciary Committee will bring Supreme Court nominees in front of them. They will engage them in this Litmus Test. They're trying to gauge the political ideology of the nominees before them. What they may do is they'll ask them some questions like, do you think there's a right to privacy in the Bill of Rights? Stuff like that, trying to try and decipher what the political ideology is of these nominees. All right, majority opinion I went over. Original jurisdiction, that is just the right of a court to hear a case first, okay? So if it is a case involving an ambassador, the Supreme Court has original jurisdiction. They only hear like 3% of their cases on original jurisdiction. Precedent, okay? So whenever this any court, federal court, makes a decision, they're setting precedent, okay? And then there's this idea of, I'm going to jump down here, stare decisis, which is let the decision stand. Use precedent when deciding future cases. Otherwise, we're going to have this very chaotic, contradictory court system. So the idea is judges should use the decisions in previous cases when deciding cases before them. Rule of 4. So this is your whole writ of certiorari process. I'm going to jump down here, writ of certiorari. So let's say you feel like you lost in a lower court. You write a petition of certiorari, and then that goes on the Supreme Court's discuss list. The Supreme Court, they discuss it, and 4 of them vote then to hear the case. That's that rule of 4. If 4 of the 9 justices agree to hear a case, it's going to be called up. That's when they've now issued this writ of certiorari. Okay, senatorial courtesy. If in a lower district court, which are basically assigned to different states, if there's an opening of a federal judge position, this is the idea that the president should go and talk to the senators from that state and see who they think should be appointed to that position. A senatorial courtesy, it's tradition, it's not in the Constitution. It basically says if the president doesn't do that, then they will not fill that position with whoever the president appoints. The president needs to go and discuss with the senators from that state any openings that take place. Solicitor General is the 4th highest ranking member of the judiciary. They will represent the United States government in the Supreme Court. If the United States government also wants the Supreme Court to hear a case, the Solicitor General would be the one to write that petition of certiorari. Stare decisis we went over. Earl Warren, I doubt to see this. Earl Warren was the Chief Justice of the Supreme Court in the 1950s and 60s. He did a lot, or his court did a lot, to expand civil rights and civil liberties in the United States. Again, doubt you see that. Okay, so we got through the judiciary today. There you go. Tomorrow, the next day, and then over the weekend, I'm going to try and get through the rest of this. And you're going to see a lot coming from me in the next couple of days as we try to get prepared for this exam coming Monday.